Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on the validity of the additions made by the assessing officer by relying upon the material which has been taken in the search of some other assessee, and the addition has been done without providing this material to the assessee, and by relying on the statement of some persons. The copy of those statements has not been provided to the assessee, and in spite of repeated request of the assessee, the opportunity of cross-examination has not been given to the assessee. The issue was that whether these type of assessments additions are valid in the absence of valid opportunity of cross-examination to the assessee of the person on whose statement the revenue has relied. This issue has been taken up by Visakhapatnam ITAT in the case of DCIT versus Vikas Kumar Chajar, and this case has reference number ITA number 212 Visakhapatnam 2025, and the matter has been pronounced in July 2025. The assessment year is 22-23. In the present case, there was a search on JMJ group on 28th May 2022. In that search, the revenue found that some program is being used by JMJ group in which there were some entries in the name of some persons, and those entries were related to cash purchases and cash sales by various persons which were mentioned in that program. And on the basis of that information, the assessment of the assessee was completed under section 143 subsection 3, and the allegation on the assessee was that the assessee has made unaccounted sales, and the addition under section 68 was made. When the assessment proceedings were going on, the assessee asked for the material which has been gathered by the revenue in the search of JMJ group, and the assessee asked for the copy of the statement and also the opportunity of the cross-examination of the person whose statement has been recorded and whose statement has been used against the assessee. But in spite of providing these documents and opportunity of cross-examination, the additions were being made under section 68 for unaccounted sales. The assessee made the argument that the assessee is not bound by the entries made by some other assessee in his books. It was the submission of the assessee that no cash trail has been found at the premises of the assessee, no cash has been found at the premises of the assessee, no documents has been found at the premises of the assessee. So, in spite that some material has been found at the premises of some other assessee, that cannot be used against the assessee until and unless that material is being provided to the assessee. When the matter was before the CIT appeal appreciated the grounds of the assessee and deleted the addition in the absence of non-providing of relied upon material to the assessee and in the absence of cross-examination. The revenue took the ground before the tribunal that the CIT appeal do have the co-terminus power with the assessing officer. It was the ground of the revenue that in spite of deleting the demand by the CIT appeal, it was the duty of the CIT appeal to do the inquiry which was not done by the assessing officer, and to provide the opportunity of cross-examination to the assessee through assessing officer if the assessing officer has not provided that opportunity. When the tribunal heard the matter, the tribunal said that in the present case, the revenue has made the addition on the basis of relied upon material which has been never provided to the assessee. The copy of statement was not provided, and in spite of repeated regular request by the assessee, the opportunity of cross-examination was not being provided to the assessee. The statement which has been recorded at the back of the assessee do have no evidentiary value until and unless that is backed by the corroborative evidence. The tribunal said that if that statement is removed from the evidence, the revenue do have nothing against the assessee. The tribunal relied heavily on the various judgments where the assessment has been quashed in the absence of a valid opportunity of cross-examination to the assessee. The cases relied were Andaman Timber Industries versus CCE, which is Supreme Court judgment, one Rajasthan High Court judgment, that is CIT Central Jaipur versus Sunita Dhadar, one Gujarat High Court judgment, that is Lakshman Bhai S. Patel versus CIT, which is 2010 judgment. One judgment is Bombay High Court, which is RW Promotions Private Limited versus ACIT, which is 2015 judgment, and one Delhi ITIT judgment, that is Amarjit Singh Bakshi HUF versus ACIT, which is 2003 judgment. The CIT appeal order was upheld and the revenue appeal was dismissed. Friends, in this case, my submission is that in this case, if the assessee has raised the ground that in the present case the assessment should have been done under section 148 in spite of section 143 subsection 3, then this ground is also a valid ground, because in number of the cases various tribunals have come out that if the addition has been made on the basis of search material which has been based on the search after 1st April 2021, then in that case the assessment should have been done under section 148 and not under section 143 subsection 3. At the end of this video, once again I am repeating the name of the case. The name of the case is DCIT versus Vikas Kumar Chhajar, and the reference number of the case is ITA number 212/Vizag/2025, and the matter has been pronounced in July 2025. Thank you, friends.